I gave up some time in lending limits, and by gave up I mean I fell asleep, which is still giving up. I'm gonna finish reading lending limits right now, and I know I gave up. So I don't know where I gave up. So I was probably in the requirements section. Oh my God, I'm not even in lending limits. I'm in Service Member Civil Relief Act. And the general requirements is section 518, 527, and 538 more than likely is where I got to. When service member exercises rights under the SCRA, this action may not be the basis for a determination that the service member is unable to pay an obligation in accordance with its terms, a denial or revocation of credit by the creditor, a change by the creditor in the terms of an existing arrangement, a refusal by the creditor to grant credit to a person in substantially the amount or on substantially the terms requested, an adverse report relating to the creditworthiness of such person, an annotation in the service member's record by a creditor or a person engaged in the practice of assembling or evaluating consumer credit information, identifying the service member as a member of the National Guard or a reserve component. And lastly, the action may not be a basis for a refusal by the insurer to insure a service member. By court order, this is another requirement, dependents of service members will be entitled to the same benefits regarding contracts for purchases of property, mortgages, repossession actions, assignment of life insurance policies, and leases unless a court determines that their ability to comply with the terms of the obligation or lease has not been materially affected by the military service. However, the 6% maximum interest rate provision does not apply to dependents except in the case of an obligation or liability that is incurred jointly by the service member and the service member's spouse. Requirement number 3 is an interest rate cap. Obligations and liabilities bearing interest, including loans which were incurred by a service member or by a service member jointly with a spouse before entrance into military service, shall not bear interest in excess of 6% per year. Interest at rates greater than 6% is to be forgiven. The amount of installment payments must be reduced by the amount of interest forgiven. For purposes of this section of the SCRA, interest includes service charges, renewal charges, fees, or any other charges except the bona fide insurance. The service member must provide written notice of and a copy of the orders for military service to be eligible for the rate cap, and a court may grant a creditor relief if the service member's ability to pay interest at a rate greater than 6% is not materially affected by reasons of the service member's military service. Now, what is the grounds for that? I want to know. So at what point can we say that we're not going to cap at 6% because we know the service member can afford it? And what court is going to rule that? Nevertheless, court actions under the requirements section. Court actions with an absent defendant. If the defendant does not appear in a court action, the plaintiff must file an affidavit stating whether the defendant is in active military service or stating that it cannot determine whether the defendant is in active military service. If the court cannot determine the defendant's military status, the court can require the plaintiff to post a bond to indemnify the defendant against the outcome. No default judgment can be entered against a person in military service without a court approving such judgment and without an attorney representing the person in military service. Judgments entered against persons in military service or within 60 days after such service are subject to be opened by the court if the defendant was prejudiced by reason of the military service. No vacated order will affect the rights of a bona fide purchaser of property at a foreclosure sale. C. The court may, at its discretion, in any case involving a person in military service, whether as plaintiff or defendant, stay such action until the person in military service is able to prosecute the action or defend his or her conduct as the case may be. In certain circumstances, the court is required to grant a stay of at least 90 days. In actions to execute judgments or attachment or garnishment of property against a person in military service that commence before or during his or her service or within 90 days thereafter, the court shall stay the execution or vacate or stay the attachment or garnishment unless the court determines that the ability of the defendant is not materially affected by his or her military service. E. The period of military service will not be used in computing any statute of limitations. F. Where the person in military service is a co-defendant with others not in military service, the plaintiff may, with the court's permission, proceed against the other co-defendant. And G. In an application for eviction from real property in which the court grants a stay, the court may grant the landlord such relief as equity may require. Contracts and loans. When an action for compliance with a contract is stayed pursuant to this law, no fine or penalty may accrue against a person in military service. If a service member fails to perform a contractual obligation and incurs a fine or penalty, the court may reduce or waive such fine or penalty. And a person who receives a deposit or installment payment for the purchase or lease of property, real or personal, may not exercise any right or option under the contract to rescind or terminate the contract or regain possession of the property if the debtor has entered military service unless approved by the court or competent jurisdiction. Courts may either order a stay of the proceedings that require that all deposits and previously paid installments be repaid to the debtor. Foreclosures of mortgages or deeds of trust securing debt originating before the debtor's military service may be conducted during the debtor's term of military service and for 9 months following discharge from active duty only by order of a court of competent jurisdiction. The court, if a motion is made by the defendant who shows that military service materially affects his or her ability to defend the case, must stay the proceeding or otherwise equitably dispose of the case. If the court stays a proceeding to foreclose a mortgage, terminate a lease, or rescind a contract for the purchase of personal property against a person in military service, the court may appoint 3 disinterested persons to appraise the property and require that this sum be paid to the person in military service as a condition of foreclosing the mortgage or resuming possession of the property. After entering military service, a contract for the purchase or lease of real or personal property cannot be rescinded or terminated for a breach of terms that occurred before or during that person's military service. The property securing a lease or contract may not be repossessed without a court order. Termination of leases. Coverage. Leases of premises occupied by a service member or a dependent for residential, professional, business, or agricultural purpose. If the leasee enters military service during the lease term, the leasee is in the military when the lease is signed, but thereafter receives orders for a permanent change of station or to deploy with a military unit for 90 days or more, and leases of motor vehicles used or intended to be used by a service member or dependents for personal or business transportation if I. The lease is executed by a person who thereafter enters military service under a call or order specifying a period of 180 days or more, or who enters military service for 180 days or more, or less, and then receives orders extending its service to a period of more than 180 days, or the service member executes the lease while in military service and therefore receives orders for a permanent change of station outside of the continental U.S. or to deploy with a military unit for 180 days or more. The leasee may terminate the lease at the leasee's option after the leasee enters military service or or the date the leasee receives the orders for a permanent change of station or to be deployed with a military unit for 90 days or more. Notice of termination. Notice must be in writing with a copy of the service member's military orders to the leaseor. In the case of a motor vehicle lease, the motor vehicle must be returned not later than 15 days after the date of the notice. Delivery of the notice must be by mail, private business carrier, or hand delivery. Effective date of termination. Real property. If the lease provides for monthly payments of rent, termination is effective 30 days after the date on which the next rental payment is due after the notice is delivered. For motor vehicle leases, a motor vehicle lease is terminated once the notice is delivered and the vehicle is returned. Arrearages. Any rents or lease amounts that are unpaid for a period preceding the lease termination shall be paid on a pro rata basis. On a motor vehicle lease, the leaser may not charge an early termination charge. Any taxes, summonses, title and registration fees, and other obligations of the lessee, including excessive wear, use, and mileage fees that are due and payable at the time of the termination must be paid to the lessee. Rent paid in advance by the lessee must be refunded on termination. If requested by a lessor, a court may modify the relief granted to a service member as justice and equity require. The Higher Education Opportunity Act of 2008 amended the SCRA by adding the applicability to federal student loans, which were not originally covered under the SCRA. This change applies to borrowers in military service as of August 14, 2008. The SCRA interest rate limit does not apply to an endorser of a trust loan made to a Canada graduate or a professional student unless that individual is a bad mother, also performing eligible military service. Eviction. No evictions may be made from housing occupied chiefly for dwelling purposes by a service member or the dependents of a service member during a period of military service if the monthly rent does not exceed the established amount. This amount was set initially at $2,400 but is subject to change annually. Life insurance. No assignee of a life insurance policy where the assignment was made before the insured entered military service may exercise any option by virtue of such assignment without a court order unless the insured party gives his or her written consent. The premiums of a policy are The premium of a policy are due when unpaid or the insured dies. Life insurance policies purchased before military service may not lapse during the term of military service or for 2 years following the term of military service for non-payment of a premium. Policy premiums become an obligation of the United States. Storage liens. No lien for storage of household goods, furniture, or personal effects of a person in military service may be foreclosed or enforced during the period of military service for 90 days or after, except by court order. State taxes. Property of a service member may not be sold to enforce the collection of taxes except by court order and on the finding by the court that the service member's ability to pay the taxes is not materially affected by military service. Health insurance. Health insurance in effect at the time of military service must be reinstated after military service without any exclusions or waiting periods, unless they would have applied regardless of the military service. Term of benefits. The rights granted to persons in military service are valid until the end of the service. Where the person has been reported missing, he or she will be presumed to continue in the service until accounted for. No period that is limited by the death of the person will begin or end until the person's death is reported to the Department of Defense. Limitations on terms of consumer credit extended to service members and dependents. What time are we at now? 14, 18. I'm going to start this section in another recording.